Georgia lawyers Bob and Irreverent D talk law. Listen up for stories about how things really happen in our legal system. Who are these guys? Dwayne Singleton, Irreverent D, is a criminal defense attorney in the state of Georgia. Benjamin O. Benson, a.k.a. Bob, is a personal injury attorney in Atlanta. Now, sit back and take a listen as Bob and Irreverent D talk law.
So I was got the call from Costco, go pick up your sunglasses. I had ordered these sunglasses.
From Costco.
From Costco. I mean, it's like the best deal in the world.
Well, it's the same brand sunglasses.
Right? And they're good. I mean, they're good.
Like diamonds and jewelry there are cheap too.
I haven't even looked at that.
Yeah.
Okay. But I get there and they show me these. And I say, small problem. They're supposed to be sunglasses. And but then I ended up liking these so much. I was like, you know what? Screw it. I'm going to keep these. Order me another pair of sunglasses that are like this because I actually kind of like these. These are nice glasses. Yeah.
Quality.
I mean,
very
good.
Lawyerly.
Listen, yeah.
You put them on, them down to the tip of your nose when you're reading the document. Ladies and gentlemen,
you know, before I needed glasses,
right?
I swear I had a prop. I would have the reading glasses, and I would just perch them on my nose. You know, so I have this young face, and you know, I always have when I was younger, before I had the facial hair with the gray in it.
Put the glasses on.
Mm-hmm. Yeah, and I'd put but before that, I would have clients say, "Oh, honey, how old are you?" Oh, yeah, you're so cute, right?
When I first started practicing, I had braces.
Oh, Lord.
Had gotten put on. And I literally went to a courtroom in Rockdale County. Judge Nation said, "Son, are you a lawyer?" He's like, "I'm going to need to see your bar card." That's the only time in my whole career that I've ever had anybody like bust me out and be like, "Hey, I need to make sure you're able to practice law in these hill pots."
The first time you ever got, and only time you ever got carded.
Right. Yeah, like nobody's ever asked to see it since. So let's do another podcast.
So here's the news.
And now, the news.
11th Circuit tosses preliminary injunction over the Georgia runoff vote. Nope.
You know, let's talk about voting.
I know.
How important it is.
It's
important to vote.
Yeah, can we pause there for just a minute?
Sure.
There's this fallacy.
Right.
There's this statement out there that people say all the time. You should never talk about religion, sex, politics.
Those are some of the funnest things to talk about.
Right? I always talk about those things because how else are you going to know if the person you're talking to is a real person or just a person cleverly impersonating a real person?
I think the problem is there's a lot of people out there who don't want to listen to you if you disagree with them. Right? And so now you've caused a divide between you and them because your politics or religion don't mix. I find it fascinating.
Right.
Because a lot of times I explain to me more because I don't quite get why y'all do that or how. But there's a lot of people who are just like, done.
I intentionally want to talk about it because I want to. Here's the dividing line, right? I disagree with you and reasonable people can disagree.
True.
Or you don't agree with me, therefore you're stupid. Right. Right? And if if you disagree with me, you're a stupid kind of person, I really just don't want to talk to you. I don't want to interact with you. It's a litmus test for finding out whether you're like a jerk that I can't deal with, right? Or a real person.
Well, you know, I stole a voir dire question, or when you're paneling a jury, I stole a question from a prosecutor one time. He said, "What type of bumper stickers do you have on your car?" And I thought,
that's a good.
It gives you so much insight, right, into some people and who they are just based on that bumper sticker, you know. So, anyway, all right, what we got?
Oh yeah, okay. Well, okay. So we're not talking about those news items. Actually, today is Public Service Announcement Day. We're going to talk about attorney discipline. So just for those of you at home who are listening and watching, here's what happens. The bar of Georgia essentially governs our conduct. And it's a certain amount of self-policing. So if I'm representing Dwayne, and Dwayne thinks I'm giving him a raw deal, he doesn't go to the Better Business Bureau or call an ombudsman. He calls the Georgia bar and files a grievance, a complaint against me for, rubbing him the wrong way or whatever. Right, and then the Georgia bar will have like a hearing and decide whether I should be reprimanded or not. Well, that's when you have things that are just like general, gnashing of teeth between people, right? But there's a heightened level that happens if the attorney has actually done misconduct,
right?
Misused funds, failed to do things almost to a criminal level. Right, and every once in a while that does happen.
And I would say it's really few and far between, considering how many lawyers are out there and how much work they do and how many cases they handle where something actually raises to that level where the bar is actually going to come in and look at it. But when the bar does, it's serious.
It's like a big hammer.
Right.
That's right. So ultimately, from a jurisdiction standpoint, the bar investigates and then makes recommendations, and then ultimately the Georgia Supreme Court is the decision maker about whether an attorney needs to be disciplined, disbarred, kicked out, whatever. And so those news items are actually published in the Fulton County Daily Report, and we actually read them every once in a while.
So not only do you get in trouble, not only do you get reprimanded, not only do you get suspended, but they put it in a paper and send it to every lawyer in the state.
Right.
And post it up in your local county.
That's right.
In the courthouse.
That's right.
Yeah. It's a bad day.
It's a bad day, but it is for good reason.
Right.
Right. So in this case, we're not going to mention names. I mean, these are published, but we don't want to pile on. This lawyer number one, was retained in 2018 by a client to represent them in a divorce proceeding, and they paid the lawyer $1,300. But he never did anything, and he failed to respond to his client's requests for information. He failed to respond when his client fired him, and then failed to refund the fee.
Well, and I'm not trying to tell other people how to do their business, but when you're looking at $300 plus filing fees, right? Just to file the divorce, and the lawyer's charging $1,258.
Right.
And you probably haven't retained the best lawyer in the world at that point.
So doesn't this go...
When you've called 15 lawyers and all 15 of them have said...
$4,000.
It's a $10,000 retainer and I need, $5 up front, right?
Right.
And then you call this guy and he's like, I can do it for $1,200.
You
might have a problem.
Okay, so there's that dichotomy then. There's that trade-off, right? If I have to hire a lawyer to do something for me and I think, oh, good Lord, it's going to be thousands and thousands of dollars that I'm going to have to pay him. I'll never see that money back, right? There's a trade-off between you get what you pay for.
Right.
Right? And maybe you don't want to choose the low-cost leader, right? We don't...
It's kind of like, hey, I can get my brain surgery done here.
Right.
Or maybe I can find a vet that'll do it for me behind his barn.
That's
for
right.
a lower price.
That's right. Or maybe I should wait until there's a coupon.
Right.
So, at any rate.
So, and I think, when you're looking at lawyers and you're looking at trying to pick somebody, one, you want to have a good rapport with them. But
That's
two,
right.
You want to make sure that they've got a good staff, right? Because a good lawyer is going to spend a lot of time in a courtroom.
That's right.
Or drafting pleadings or doing other things where the day-to-day hand-holding that needs to be done, making sure you get your pay stubs and drop them off at the office, and making sure that you bring the paperwork that he needs to answer the questions. A lot of times that's handled by support staff. So I know, like at my office, I have answering service that answers and records all phone calls, and then you go to the intake person, and then you go to your assigned paralegal that's handling your matter, and then you get to the assigned attorney, because we have multiple attorneys at the firm. So you've got this layer of people that are all taking care of you, making sure that nothing gets dropped through the cracks.
Why can't I just you're saying that I can't just pick up the phone, call your office, and get my lawyer on the phone? I mean, you would be my lawyer, right?
You can. You can set an appointment and get me to meet with you or sit down and talk with you and go over whatever's going on. And a lot of my clients, especially as we're getting closer to trial, have my cell phone.
Yeah.
Because I've called them so much to talk about trial prep. But I can't be in trial with a jury and my client for 2 weeks and just let the office go to hell and my other clients not have any attention.
That's right.
I mean, the reason why you're able to do this higher level of representation where you're gone and you're staying in a hotel room out at the courthouse where you're at with your client so that you can make sure that all this is getting done and you're meeting with them daily and talking with them daily and going through it, is because you've got this support staff. And it's hard when you're starting out as a new lawyer, because you may be a fantastic lawyer, right? You just don't have the support staff yet, and that's fine.
Right.
And you want your attorney to be responsive and call you and take care of you. But, you've also got to have some big red flags that if it's just one guy running his office and he met you at the,
Waffle House.
At the Waffle House.
Right.
And you call his cell phone that he gave you and it's, he doesn't answer, and you text him and he doesn't respond.
That might be a red flag.
Yeah, that would be a giant red. And I think that's, it goes back to, if the attorney is taking your money and not representing you and not answering and returning your phone calls, then he's stealing from you, right? So, and we're not supposed to steal from our clients.
That's generally against the rules, right?
Right. So, and if you're taking and not returning, then we're just stealing. I think that's basically what happened here. Is he paid a retainer, and then the guy just ghosted.
Right. Never returned, didn't do anything, and didn't return the money.
Doesn't answer anything, and then refuses to return the money.
Yeah. Well, so the red flag is, well, if you can't ever find out what the status of your case is, right? You may not be able to get the lawyer on the phone.
Right.
Right. I mean, back to that original point, like how many times do we call a doctor's office and expect to get the doctor on the phone? We don't, right?
No, but there's sometimes when the doctor needs to call you back, and he does.
That's true. Right. Or get a message to you. Sure. Don't take those pills.
Right.
Exactly. Right. So, I mean, you have to be able to get meaningful information about what's happening.
And, from a criminal defense standpoint, what's sometimes frustrating to clients is, they retain us. We go have a bond hearing where they get bonded out of jail. We may have a preliminary hearing. Those are all handled right at the very beginning. Okay. Then I'm going to go out and talk to the investigator or the narcotics agent. That's all right at the very beginning. And a lot of times they're going to say, look, DA's already told me not to talk to you anymore because what happened on that last case.
You're talking about the investigators?
Yeah. Last time I talked to you, I got myself in trouble, so I'm good,
I made the mistake of talking to you before.
Right. So at that point, I can still go out and maybe interview some witnesses or that kind of thing, which we do through an investigator that we use. But there's not a whole lot that might happen for another year. Right.
It's just a lot of dead time, right?
Right. And so the clients are like, well, what happens now? And they're worried and scared.
What's the status of my case?
What's the status of my case? You should be able to call somebody should say, look, you're still unindicted. The next grand jury meets, in February. We'll check for it in February. Right. Blah, blah, blah.
That's great for your practice, but not for my practice. There are times in my practice.
With PI, you stir the pot. You got to make it move forward.
Not just that, but you can rightfully tell your client, listen, they still have not charged you with anything. The longer we can string this out, right, the longer you're just no threat of even being in jail.
As long as you're not in jail, I'm winning.
That's right.
Let's keep winning.
But on my practice, it's a complete opposite thing. I'm supposed to be getting money.
Right.
Right. And every day that I'm not getting money is a problem for my client. So we actually do.
And when we're working on cases together, it's a problem for me because I want my money too.
Right. So the way we handle that part is, we're telling our clients, okay, you're in this phase. This is the next phase. This is what's going to happen. Right. If your attorney's office is not telling you, okay, this is kind of the process, like you need to get some kind of meaningful answers from that attorney's office, or it might be a red flag, right? So back to the original point, you get to be honest, I don't return phone calls. I tell potential clients, look, I'm a lawyer. I'm not any different from any other lawyer. I don't have a voicemail. You can't leave me a message. But if we need to talk, my staff is going to set a conference call on my calendar.
Right.
Anytime you want to talk about the substance of your case, about strategy, about what's going to happen, about what we're going to do, because we make decisions as a team, you're going to be put on my calendar at 2:15 on a Tuesday or whatever it is, right? And I'm going to pick up the phone. I'm going to know what's going on with your case. Right. Before I pick up the phone, I'm going to say, okay, it's time to talk.
Well, and when I like to talk to people as well, I like to have the file in my hand.
That's right. The worst time,
I like
Dwayne,
to look over it.
Yep.
When I'm driving down the road in my car and you've got my cell phone number and you're like, hey, what's up? And
what's going on with this?
Well, I had this happen one time where I'm like, man, I talked to the DA. He said this and that.
Oh, God, no. It was the wrong client.
Talking to the wrong.
No. Oh, God. Dude. No.
Okay. You talk about
that's the third.
And downs.
Yeah, that's the third nightmare.
Right. And I come back and they're like, that's the same first name, different last name. And, my heart drops. And now I got to call this guy and be like, hey.
Oh, no, it turns out you really are going to jail?
I don't know. Yeah, right. I don't know what's going to happen yet, but I thought I was talking to somebody else. So you always want to have your folder there in front of you, make sure you know what's going on.
And that's what I tell them. I say, listen, love you. I'm looking forward to working with you, but the worst time to talk to a lawyer is when you're calling. Right? Because, again, love you, but I'm not thinking about your case when you're calling.
Well, it's like when I call a prosecutor's office or if you call an insurance agent, they don't take it immediately. They get your information. They call you back.
I got to look at the file.
On their time so that they're ready and they're prepared and they know what's going on.
That's right.
So what happened to this guy? Did he lose his bar license?
This is my insight. I think had this lawyer refunded the fee, they probably just gotten away with like a slap on the wrist. But what ended up happening was there was a complaint filed, and there was another couple of things that happened, and then the lawyer didn't respond to the complaint, and then basically he was just literally just ghosted. Right. And so the Supreme Court said, yeah, you can't be a lawyer if you can't even bother to answer the questions about how this person is complaining about your conduct. That's right. Yeah. So that's the news. Now we're going to take on, what is our section? Can I sue for that?
Can I sue for that?
Hey, so if somebody wants to ask us a question instead of just randomly sending emails out into the universe, where do they need to send these emails to?
bobandidtalklaw@gmail.com. Bob. That's me.
B-O-B.
And ID.
Is it A-N-D?
And ID.
And ID.
And ID, which is Irreverent D. Talklaw@gmail.com. Bob and ID talklaw@gmail.com.
And we'll answer your questions.
And we will answer your questions. No, we will absolutely answer your questions.
100%.
And it will be 100% right.
And if not, we'll call our sponsor.
So this person was wrongfully terminated because they complained about their coworker to human resources. Okay. And the coworker, this is where it gets saucy. The coworker and the supervisor and the human resources director are all super tight with each other.
Right.
And so the guy who complained about the coworker was fired. So
nothing
can
like
I
good
sue?
old-fashioned office politics.
That's right. It's all politics. Of course it's all politics.
So can you sue for that?
Yes. The answer is yes, you can sue for that because our long-running statement is if you have $300 You have a crayon and a piece of paper, you can sue for anything.
Do you know how many people are going to be filing lawsuits now with crayons? We're going to have some judge call us in somewhere and be like, you guys need to stop saying crayons.
Seriously, stop.
They need to do it in blue or black ink, please.
It could be blue crayon.
That's right.
Actually, this is a funny side note. There was this attorney who sent me a request for admissions. It was in a workers' comp case. I used to only exclusively do workers' comp cases, and so kind of all the workers' comp lawyers know each other, and so this lawyer, I had worked with her in the same law firm.
Please admit that you've done everything wrong and you owe us a bunch of money.
Yeah,
A, B, and C.
So she's so you get these discovery requests, right? You get interrogatories. These are questions you have to answer.
You have your lawsuit.
That's right.
And then attached to that can be questions, or you can send them later.
That's right.
Interrogatories, written questions.
That's right. Requests for production of documents.
They're asking for documents.
That's right. You have medical records. Please give us a copy of the medical records in your possession, right?
And the client always says, I'm not giving them this.
It's not
they
relevant.
Don't need to have
We'll
my
talk about
stuff.
We'll talk about that in another episode. That's a whole nother episode. So this lawyer had she had snuck the request for admissions in between the interrogatories and the request for production of documents, so that if you went through the stack, you would maybe not have seen that there was a request for admissions in there. And of course, in the law, if you're in litigation and you have requests for admissions,
especially if you're represented by a lawyer, and there's requests for admissions and you don't answer them, they're deemed to be admitted. Done.
Right. Please admit you were not injured. Please admit there is nothing wrong with you. Right. And so she had snuck those in there, and I mean, luckily I had gone through it a second time, and I was like, oh, there's requests for admissions in here. Oh, that sneaky lawyer. So what I did was
instead of sending them separately, she attached them to the complaint?
No, she just stuck the admissions in between the interrogatories and the request for production of documents.
How many times she got away with that and just nailed somebody?
Well, I don't know. But whatever the case, so I was really ill that day.
Right.
And so I literally took a piece of paper and I took a crayon and I wrote 1, denied. 2, denied. And then I faxed it. I faxed it to her in full color crayon. Yep, did that. Where were we?
I tell people all the time, they'll call, they're like, I got this lawsuit and I don't have money for an attorney and I don't know what to do. I was like, look, just deny everything.
That's right.
Until you can figure it out. Yeah. And then you got to have an attorney or somebody, because it's really difficult to go into a courtroom by yourself. But you can do it by yourself.
You could do it by yourself.
But you got to file something with the clerk's office or you're in a mess.
Yeah. So going back to the original question, can you sue for that? Of course you can sue for that. It's not going to get anywhere for several reasons. One, in Georgia in particular, unless you're in like a labor union, like collective bargaining agreement.
Right, we got some kind of contract.
You have a contract, right? You're not entitled to a job. So there's no such lawsuit in Georgia as wrongful termination. It's not a thing. Now, if you were fired and it wasn't your fault, your remedy is you can get unemployment benefits.
So
right?
Why when I Google wrongful termination do attorneys pop up?
Well,
Google algorithms and search phrases.
Yeah, right? Those things. Well, I don't know, because I've never Googled that. Right. So at any rate, there is no such kind of case as wrongful termination unless there's like a collective bargaining agreement that says, or you're a civil servant where there's a contract that says we will not fire you except under these circumstances.
Well, what if she said they created a hostile work environment and they did it because she was some religion that nobody else was?
Because of the style of her hair?
All these Karens are one religion and she's another. Then would she have a lawsuit?
Now that is different. Okay. So what we have in federal law is what we call protected classes. right? You cannot discriminate against another or discriminate against an employee and fire that employee because they're male,
Right.
or because they're Muslim, or because they're gay, or because of any of those protected classes.
But just getting fired because you don't get along with everybody else.
Yeah, if it's politics, it's because they hate you.
Not a deal.
Fair game.
Right.
You can get unemployment benefits, but unless you're going to file a federal lawsuit saying that you're one of these protected classes, internal politics is just kind of fair game. It's the way it goes. So, I mean, you can sue for that, but it's...
So she probably
not really
should have
gonna go
called one of our sponsors
Yes.
and had them complain.
Do you have the read for the sponsor? Hang on. I have it.
You got it? There you go.
These guys, I love these guys. Are you sick and tired of your neighbor leaving his trash can on the curb all week long and never bringing it to the side of the house? Or you have a coworker that brings fish to work? This is the one.
Or other employees that go to lunch together and don't invite you.
Ooh.
Yes.
That's right.
Yeah.
Maybe you wouldn't sue them, but maybe you would call myown.karen.com.
And what exactly does My Own Karen do?
So, My Own Karen will custom make your own Karen message saying all of the things that you just don't feel qualified to say, or you are concerned about confronting your coworkers about.
Because you don't want to get fired.
Right? You don't want to get fired and then have...
But you want them to know how you feel.
That's right.
Right.
So the Karen, myown.karen.com has this service you can pay on a monthly basis, and they will have full-on Karen messages that you can send to people. And I think I
don't think it's fair how you treated Susie last
right.
week. I've been watching your group of 3. They're
That's
terrible people. Blah blah blah.
Nepotism.
Yes.
Yes.
Got
Nepotism. That's
Got
very
it.
good. So
Anonymously.
You can be anonymous. I think I haven't used the service, but I can't imagine that they didn't have some kind of way to mask the email that it comes from. I think it. Yeah. So myownKaren.com, myownKaren.com.
myownKaren.com.
We've got one last thing to cover, and that is the mailbag.
It's time to dip into the mailbag.
What's in the mailbag?
Mailbag. My stepbrother is 15 years old,
Okay.
lives with me and my dad and my gold-digging stepmother, and is super creepy.
The stepmother's super creepy or the brother?
The stepbrother. Oh, this must be girl.
Okay.
Girl has a stepbrother, and living, and he's super creepy. Can I get a restraining order against stepbrother? That is in your... that is... I am completely out of that.
If you find the right judge on
My name is Paul, and that is between y'all. I do not know. Tell me.
If you find the right judge on the right day,
Yes.
you can probably get a TPO
Against stepbrother.
against stepbrother because he's scary, he's been violent, he's made threats against you. Anything that could cause you this immediate fear of immediate bodily harm, okay? Some judges are very cautious about issuing these TPOs or temporary protective orders, but other judges are so scared not to because let's say that they go and
What happens if he loses
and they
it?
try to get this TPO and
Right.
you say, no, I'm not going to give it to you, and then stepbrother axes her up next week, right? So the worst
That's
thing
not
that's
going
going to
to look
happen,
good. That's not going to look good when you're trying to get reelected as the judge.
Right. So
That's
they put
right.
these TPOs in place. They're good for 30 days. And at the end of the 30 days, you show up and have a hearing. So you're kind of guilty until proven innocent, right? And at the
Stepbrother, creepy stepbrother.
Right. No, well,
Allegedly creepy stepbrother.
decide if they're going to
Okay.
go forward with it or not. Now, some courts, depending on where you file it, because some places they make you file it in magistrate court. Even though it's a Superior Court thing, they'll designate a judge to hear it. You know, they may say, hey, let's just do a good behavior bond. We'll go
What's
and have
that?
You go and have a hearing about
Is that
what
a whole
all's-
another episode?
Well, you
Okay.
go have a hearing about what all's going on between you, and the judge says, okay, here's the deal. Y'all leave each other alone.
Okay.
I'm going to issue
It's like an judge intervention.
good behavior bond.
Okay.
Y'all's bond is going to be $1,000 each, and you're going to be incarcerated
If you
y'all
don't
mess
behave.
with each other anymore, right?
Okay. Wow.
Yeah, and so,
That really happens?
yes, that really happens.
Okay.
And so and then violation of that bond, that good behavior bond, can be a crime of aggravated stalking for not doing that, and you get arrested and you sit in jail.
And you lose your $1,000.
Right. And so with the TPO, or the temporary protective order, we go back to the situation where if somebody makes something up, right?
All right.
Then you could be out on
that
the
never
street,
happens.
out of your own house, and have to
Didn't
wait.
we cover this in a previous episode?
Yes. So
right.
You've got the situation where somebody said, hey, he's tried to hurt me, and it's not even your house.
Right.
Right. And then you're out on the street for 30 days. So the difficulty here is because they're family members. Like, where does he go? Where does he live? What does he do?
Right. Because stepmother is already living with them.
Right. So, it probably wouldn't get stepmom out of the house, but you might be able to get creepy stepbrother out. Right. Now, just being, mean, normal stuff, most judges are going to see through that and say, hey, there's nothing here.
Right.
But,
you're in separate bedrooms, just lock your room.
Yeah. But if you go in and say, hey, she threatened to kill me.
That's a whole nother thing.
Yeah.
All right. Well, thank you for joining us on this episode. Listen, make sure that you like our podcast or
subscribe.
Thumbs up, subscribe.
Ring the bell.
Ring the bell. That's right. We look forward to seeing you in the next episode.
Thank you.
Thanks for listening. Tune in next time when Bob and Irreverent D talk law.